Welcome to Tort Talk. We're a couple of weeks away from the new year. We've got Joe Fantini here. I'm John Robinson, Marc Rioux in Atlanta. We're going to talk about a few torts where we have some not so great news to share, but we're always giving you the open, honest opinion and news about what's going on in mass torts. First, we're going to talk about Roundup. Joe, we had a huge development in this litigation. We have the Solicitor General now recommending that the Supreme Court actually hear Monsanto Bear's appeal on the preemption issue. We've been talking about this for weeks, for months. What does this actually mean for the litigation going forward, and where do we really go from here?
This was a huge development, like you mentioned. Monsanto's Hail Mary got answered. Basically, what was going on in the litigation is we had a split between the jurisdictions about whether or not the plaintiff's failure to warn claim were preempted. So just by way of background, usually in a drug case, the FDA approves the warning and a label on a medication. And in those cases, the defendants say, hey, we can't alter or change these labels in any way at all because the FDA approved it. They're trying to now, in this case, Monsanto, expand that law, saying that in this instance, the EPA approved the warning label for Roundup and didn't require a cancer warning, and therefore they weren't able to change it at all. And because of that, all of the failure to warn state law cases and those claims should be kicked out. There was a split between a couple courts on whether or not that was the correct application. The majority of the courts said that the state law claims can move forward, but Monsanto appealed it up. The Solicitor General just came back and said to the Supreme Court, I recommend you take up this issue and make a final ruling. It's really important because typically when the Solicitor General makes a recommendation, 60 to 70% of the time the Supreme Court ends up following what the Solicitor General suggests. So we'll know in January if this case is going up, but it's a huge development and definitely a win for Monsanto. But there's still a lot to be positive about on these cases, and the cases won't die even if we get a bad ruling.
And this is specifically addressing the state filings, not the MDL?
It's going to apply to both because even in the MDL, we apply state law claims, but it's about whether or not the failure to warn claims can survive. In these cases, though, we have other claims as well. We have defective design, we have negligence, we have manufacturing claims. So even if the failure to warn state law claims get kicked out, the cases still go forward. Seth talked about this at your Roundup podcast a couple weeks ago. He was right on the issue, predicted it exactly as we're seeing it play out now.
Moving on to Zantac, we feel important to provide both positive and negative updates to keep the listeners informed. So we had another setback coming out of Delaware State Court last week. What did the court address in the most recent ruling?
Like you said, Marc, it's important to keep it real here. That's why everybody tunes into Tort Talk. But what was going on in the roller coaster of the litigation is we had scored some wins in Delaware State Court where the trial court allowed in our experts. The defendants appealed that decision up to the Delaware Supreme Court. The Delaware Supreme Court said the trial court applied the wrong standard and plaintiffs' experts didn't meet the threshold and they should be excluded. In response to this, the plaintiffs filed a motion seeking to have an amended scheduling order put in place and allowing us to now put forward new experts based upon what we considered this new and heightened standard set forth by the Delaware Supreme Court. Unfortunately, the trial court just came down last week in about a 10-page opinion and said that wouldn't be fair. That's not the proper way to do it, and is asking for further briefing on the parties about how this should play out and what the litigation looks like going forward. So the plaintiffs said hope that we would get to come forward, submit supplemental amended expert reports to further support our claims. It doesn't look like that's going to happen. So the Delaware Supreme Court, it's definitely favoring the defendants right now. So we're going to have to keep an eye on this and see how it shakes out for the rest of 26.
Yeah, this was a litigation that we all thought was gone a few years ago, and then it came back when Delaware opened up, and now we're dealing with some turmoil again. So appreciate the updates here. We're going to move on to toxic baby food. This is one that's been around for a couple of years. We had a surprising expert ruling come out of California State Court last week. This week, we have the Daubert hearing in the MDL. Where do we currently stand with the toxic baby food litigation?
Like you mentioned, John, we had the parallel proceedings going on like we often do in these mass torts in the state court in California, and then also in the MDL, also happens to be in California federal court. but these cases were really moving in parallel. The timeline was really similar. And a pretty surprising ruling, I'll say, is that the state court trial level excluded the plaintiff's toxicology expert and said basically the expert wasn't able to pinpoint which one of the baby food was being used by the plaintiffs and how that attributed to the problems that they were having. It ended up excluding the plaintiff's experts, which is definitely a setback for us in that litigation overall. And that's on the state court level. And now this week, there's an entire week dedicated to Daubert hearings, various experts on various issues before the MDL judge, and we'll probably have a ruling on that within 90 days or so. But these are crucial issues, and if we're able to survive the Daubert in federal court, this litigation is going to blow up, and we're going to see a huge increase in filings. But even with the setback in the California state court proceeding, we still have some optimism. But again, that wasn't a good day for plaintiffs, and it's important to keep everybody updated about what's really going on in these litigations.
For toxic baby food, because we are dealing with a number of issues that are affecting children, can you clarify for those watching, what are the actual effects on the children that are being looked at in this litigation?
The two main signature injuries we're looking at, it's autism and ADHD. So it's the similar type injuries that we're seeing in that Tylenol litigation. So what we're alleging here, it's a similar plaintiff pool almost with these minors, but we're saying that they used this toxic baby food when they were very young. So instead of the mother taking the Tylenol while they were pregnant, it's these children actually taking it. There's criteria for a certain amount of time for a number of years, and then developing and being diagnosed with autism and ADHD. So it'll be really important what the MDL court decides here. But remember, these are minors, and there's more time in these cases to develop our theories, right? We're not facing a statute of limitation. So I could see this litigation going to state court, maybe in other jurisdictions like Illinois or Philadelphia, if we end up not getting the best ruling out of the MDL court.
JPML, hopefully some positive news for plaintiffs to end the week off right. We had the last JPML hearing in Austin, Texas last week. What are the key cases in front of the panel, and when should we expect a decision?
Yeah, we're all waiting to hear from the panel. Typically, we get a decision within about 2 weeks of the hearing. The last hearing was on December 4th. This is the last hearing of 2025. There were really a few cases that everybody's watching. The first is the weight loss litigation. We already have the MDL formed for the gastrointestinal injuries. Now we're waiting to see whether or not these vision loss injuries are going to be combined into the same MDL with those injuries, the gastrointestinal ones, or if there's going to be two different MDLs likely before the same MDL judge. That's what we saw happen on the state court level in New Jersey. I'm expecting the similar ruling coming out of the panel here. And then the other cases that we're watching, finally getting back to what everybody's focusing on in 26, is going to be these platform cases. So we're looking to see whether there's going to be a Roblox MDL formed. These deal with the more sexual abuse type claims that are coming out. And then there's also going to be a petition heard about whether or not a video game addiction MDL is going to be formed. So we have some traction in state court level for those type of cases, but we're really watching those three rulings to come down. I think we'll end up pretty positive outcome from this with getting these MDL forms, and then those will probably be some of the biggest cases in 2026.
We still got a couple weeks left. There's still a bit more news that we'll probably see roll out over the remainder of the year. Make sure if you're watching us on YouTube that you subscribe to our channel to see exactly when we release our newest episodes of Tort Talk. Make sure you subscribe on Apple Podcasts. You can watch us on LinkedIn. You can see us on Instagram, on Facebook. Wherever you are, we are. Thank you so much, Joe, for joining us. We'll be back next week with the latest updates in mass torts in the best 10 minutes in mass torts each week here on Tort Talk.
Thanks, Joe.
Thanks, guys.